The Justice Department has now released a big new batch of documents in the Jeffrey Epstein investigation, and these include new details about Epstein's one-time friendship with President Trump. Look, there is a lot to go through. We said it's like more than 10,000 pages, so we are digging through this, but this is what is seen so far. In a 2020 email, an assistant U.S. attorney for the Southern District of New York wrote that Trump traveled on Epstein's private jet, quote, more times than previously has been reported, at least 8 times between 1993 and 96. And on a flight in 1993, according to the email, there was just 3 passengers: Trump, Epstein, and what's described as a 20-year-old woman.
The Justice Department has released more than 10,000 pages of documents connected to the Jeffrey Epstein investigation. Within those files are renewed references to Donald Trump's past association with Epstein. There are no new criminal charges against Trump in this release. However, official records bringing his name back into circulation inevitably trigger political fallout. And this development comes at a moment when another major issue is unfolding behind the scenes. Mark Meadows, Trump's former chief of staff, has reportedly cooperated with federal investigators. Meadows served during the most critical stretch of Trump's presidency, overseeing the period from the 2020 election through January 6th. He had direct access to internal discussions, legal strategies, and post-election planning. Now, according to reporting, he has provided testimony under immunity.
The evidence we're learning about are recently revealed text messages suggesting former President Trump's White House chief of staff, Mark Meadows, was working with some GOP members of Congress to overturn the 2020 election.
That's right. The texts were exclusively obtained by Talking Points memo from the House Select Committee. They show communications between far-right activists, state politicians, and 34 congressional lawmakers. In all, there are more than 2,300 messages detailing alleged efforts to undermine the American electorate.
The released communications show Meadows was actively engaged in conversations about election challenges and alternate elector strategies. When investigations intensified, Meadows faced mounting legal exposure. He ultimately accepted immunity and provided information to prosecutors. Reports indicate he told special counsel Jack Smith that allegations of widespread election fraud lacked supporting evidence, and that Trump had been informed of that assessment at the time. From a legal standpoint, that detail is significant. Establishing what a president knew and when can be central to questions of intent. Meanwhile, Meadows is also facing state-level charges in Arizona related to the fake electors effort, alongside Rudy Giuliani and other Trump allies. That trial is scheduled for 2026. In response, Meadows is seeking to move his case to federal court by arguing his actions fell within official duties, relying in part on the Supreme Court's presidential immunity framework. That argument creates an unusual dynamic. A legal doctrine associated with Trump is now being used in Meadows' own defense. But legal risk isn't the only pressure point.
People are very angry that pictures are being released of other people that really had nothing to do with Epstein, but they're in a picture with him because he was at a party, and you ruin the reputation of somebody. So a lot of people are very angry that this continues.
The Epstein document releases continue to generate headlines. While the current disclosures do not allege new wrongdoing by Trump, repeated mentions in official investigative materials keep the association active in public discourse. Even absent criminal findings, proximity to a high-profile criminal case carries reputational consequences. Reports suggest unease within Trump's circle regarding the ongoing release of documents. Now consider the timing. You have a cooperating former chief of staff, you have state criminal proceedings approaching, and you have document releases reviving past associations. Individually, these are significant developments. Together, they create sustained scrutiny. If trials proceed as scheduled, courtroom testimony may clarify who participated in discussions, what was proposed, and how decisions were made. Meadows' role as chief of staff positions him as a potentially significant witness, depending on the scope of his cooperation. Beyond the legal process, these developments reflect a broader shift within Trump's former inner circle. Several past associates have either testified publicly or entered cooperation agreements in various investigations. Each instance alters the dynamics surrounding ongoing cases. For individuals facing exposure, the calculation often centers on legal risk versus political alignment. Immunity agreements can provide protection, but they also introduce new testimony into the public record. At the same time, document disclosures related to Epstein continue independently of election cases. That parallel track ensures sustained attention across multiple fronts. Taken together, the situation involves federal cooperation from a former chief of staff, state-level criminal proceedings scheduled for 2026, ongoing public release of investigative records tied to Epstein. Each element carries distinct legal and political implications. Combined, they create an environment of heightened scrutiny that is unlikely to dissipate quickly. How events unfold will depend on judicial rulings, evidentiary standards, and the pace of additional document releases. Courtrooms, rather than campaign rallies, may ultimately determine the next phase of developments. For now, the intersection of testimony, trials, and official records keeps this story active. And as more information becomes public, its broader impact will become clearer.